So here's your room with an attached bathroom.
Oh, it's quite nice and spacious as well. Yeah, I kind of like it.
Good to hear that.
So this is your room, and I guarantee you that you have a peaceful stay in this house.
Oh, but I thought something happened here.
What is fraudulent misrepresentation? Fraudulent misrepresentation is a civil tort arising out of contract law. It is a false statement of fact that used to cause or induce the other party enter into a contract. For example, if a jeweler sells you a diamond ring, which you later discover is crystal, then it shows that it is a fraudulent misrepresentation. Fraudulent misrepresentation is the most serious type of false statement in contract law, and it can be in the form of anything such as written, spoken, gesture, or made through silence. Those forms are designed to deceive the other party, including innuendos, half-truth, or silence when there exists a duty to speak. So, how you can prove that a statement is fraudulent? Lord Herschel defined that fraudulent misrepresentation as a statement which is made either knowing it to be false, without belief in its truth, or recklessly or careless as to whether it be true or false. The remedy will be ground in fraudulent misrepresentation was rescind the contract. As contract based on false claims are avoidable, hence both parties must return anything they receive from the other. So, how about silence? Is there any duty to disclose material facts? Generally, in a contractual relationship between parties, there is no duty to disclose anything to the other side. Mere silence does not constitute as a fraudulent misrepresentation. However, once a party to a contract has disclosed some information, it has a duty to disclose all of that information completely, because partial information is misleading information. So, is the standing in English position and Malaysian position the same, or is it different? If the silence is in itself is equivalent to speech. Next, is there any reforms of tradition of the law for best practices to achieve fairness and equity among the contracting parties when common law does not treat silence as misrepresentation?
The effect of the maxim caveat emptor is that the other party has no duty to disclose problems voluntarily. Thus, if one party is laboring under a misunderstanding of terms, there is no duty on the other party to correct it. There is no obligation to disclose facts which might influence the other party's decision. The requirement for this rule to apply is that there must be a complete silence, as a single word, a nod, a wink, or a smile from one party may constitute misrepresentation because it might create the impression in the mind of the other party that particular facts are being affirmed or denied. As it is established in the case Bradford, Trade Equitable Benefit Building Society and Borders 1941, mere silence, however morally wrong, will not support an action of deceit. But if information has been asked for, then there is a duty to disclose the truth. In Smith and Hughes, claimant purchased new oats from the seller. The seller was aware that he wanted to look for old oats but kept quiet during transaction. After purchasing, the buyer found out that the oat is new and has no use for him. He sued defendant under mistake and misrepresentation. It was held that the claim was unsuccessful as the buyer was not misled by the seller to buy oats that has no use for the claimant. The buyer himself should be aware and the defendant has no duty to dispel his wrong belief. However, there are exceptions to the general rule. Active concealment of a defect in goods to be sold amounts to a misrepresentation. If goods are being sold whereby known defects have been hidden from a prospective buyer, then there is potential for misrepresentation to take place. It is sometimes expected that a seller of a property or a car, for example, is likely to tidy up its appearance before trying to sell, particularly if repairs are actually required. Next, contracts uberi fide impose a duty of disclosure of all material facts because one party is in a strong position to know the truth. Examples would include contracts of insurance and family settlements, which are treated as being of the utmost good faith and require the contracting party to disclose all the relevant facts, even if the other party has not asked for it. A material fact is something which would influence a reasonable person in making the contract. If one party fails to do this, the contract may be avoided. Thus, in Labor and Cooperative Insurance Society, a woman who was renewing the insurance on her jewellery should have disclosed that her husband had recently been convicted of conspiracy to steal. The fact that she had not mentioned this meant that when some of her jewellery was subsequently stolen, the insurance company was entitled not to compensate her under the policy. Another exception is that partial non-disclosure may amount to misrepresentation. The representer must not misleadingly tell only one part of the truth. Thus, a statement that does not present the whole truth may be regarded as misrepresentation. This can be seen in Demo and Hallett, the statement that flats were fully let when in fact the maker of the statement knew the tenants had given notice to quit was capable of being a misrepresentation. Statement that is true or believed to be true subsequently becomes false amounts to misrepresentation, where a statement was true when made out but due to a change of circumstances has become false by the time it is acted upon. There is a duty to disclose the truth. So, it is clear that a party has no duty to disclose voluntarily subject to the exceptions. Here comes a question. Is there a duty to discover the truth of a representation? Let's see the case of Redgrave and Hurd. In the case, a solicitor joined the partnership in the solicitor's firm. He was told that the firm makes £300 of income per year. He was given the opportunity to look at the accounts, but he did not take up the offer to check the accounts. In fact, the income was only £200 per year. It was held that the solicitor was not under a duty of diligence to discover the truth of R's misstatement. The fact that he refused to check the accounts shows that he relied on the statement made. He was entitled to rescind the contract as English law does not require the party to disclose the truth voluntarily, even if the party has the means to disclose the false statement.
According to the points being mentioned by my previous group member, it is possible to wrap up the discussion by saying that, generally, parties prior to the entering of agreement have no obligation or duty to disclose all of the information acquired by one party but not to the other. Even though there are some exceptions or in other words safeguards for the other party that are being deprived due to the possession of incomplete information in certain circumstances, however, such protection is deemed to be unsatisfactory. There are in fact several arguments in favor of the disclosure of information, and such discussion should begin with morality. An illustration was being drawn by Chief Justice Cockburn in Smith and Hughes, where it is said that a man would unwilling to take advantage of the ignorance of the seller if he is one of tender conscience or high honor. It was being alleged that if one knew about the fact that the other had no knowledge of a particular information and still yet to disclose it was deemed to be a kind of moral fraud. Despite of all the positive view in disclosing the information, the rule governing the duty of disclosure is applying to be quite outdated and restrictive in the UK, as it only covers limited ambit of law and an expansion of reform may be needed. In the article of mistake disclosure information and the law of contract, Anthony Kronman had developed two main concepts in tackling the disclosure problems, which could be made as a reference in taking into account the reformation in the area of the duty to disclose information. The way in acquiring information is a sole determinant as to whether the information should be disclosed. For instance, it is suggested that one has the duty to disclose information that's being advantageously acquired, meaning that the parties collected the information in an unplanned situation and there's non-economic incentive that will sufficiently justify the disclosure of such information. Nevertheless, there's only a limited ambit with regards to this kind of incentive that might eventually result in one being provided the additional information even if the social relationship doesn't exist in the first place. On the other hand, Corman's view was that the information that will not be asked to disclose refers to those which are acquired by a deliberate investment. The reasoning behind this is that the incentive to make such investment will be diminished significantly, and if the parties are bound to disclose this information, they might end up lost interest in investing. Such investment would then generate a return. Such argument was being supported by a US case, Late Law and Organ. However, the development had encroached into the area whereby such information may still be required to be disclosed by looking at the relationship between the parties. The notion of having such additional categories was due to the fact that the previous approach in which the information being prevented from disclosure due to the deliberate process is way too broad. The idea of having such an addition is quite satisfactory, as the amount of aggrieved party due to the incomplete information might be comparably lower as there are better safeguards provided to them. Unfortunately, the distinction between these two kinds of information is rather blurred and difficult to determine. And attention might be drawn to the Islamic doctrine of caveat emptor while propounding the idea of reformation in this area. For instance, under this doctrine, the buyer had the option to cancel the contract even though the sales had been concluded. The rationale behind this is that the seller will be deterred from a sort of cheating in the transaction. Conversely, under the common law, the fact that the buyer should be responsible for the careless and unskilled judgment in which the seller had provided the chance for the buyer to inspect and discover the defect of the good will suffice. Therefore, any failure in providing information regarding the defects will not give rise to any liability on the part of the seller. It is upon that, if the Islamic doctrine were to be adopted under the common law, the buyer's interests will be safeguarded to a greater extent, and potentially the society will be more protected from the contemporary problems in the transactions. However, compared to the common law doctrine, this seems to be more harsh on the seller in the sense that they are being imposed an obligation to inform the buyer about the actual condition of the subject matter, which might prevent them from entering into a sales agreement as well as maximizing their profit. This is because the buyer might have special requests such as a reduction in price if the quality is defective. All in all, there are indeed different methods derived from different jurisdictions in dealing with the duty to disclose information. It is important to look at the positive and negative side of each method when deciding the reformation bit on this duty in order to make the reformation more satisfactory.
So, America has banned the use of Google on Huawei's phone.
So this is our new Huawei's product.
But I heard someone say Google banned on Huawei phone.
Oh yes, it's banned on Huawei's phone.
So Huawei cannot use Google anymore?
The general rule is that mere silence or non-disclosure does not constitute fraud, but there may be certain circumstances under which silence or non-disclosure may constitute fraud. This is reflected in the explanation in Section 17, which states that mere silence as to facts likely to affect the willingness of a person to enter into a contract is not fraud unless the circumstances of the case are such that it is the duty of the person keeping silent to speak, or unless his silence is in itself equivalent to speech. Illustration A to and D to Section 17 show how the general rule regarding non-disclosure operates. Illustration A sells by option to B a horse which A knows to be unsound. A says nothing to B about the horse condition. This is not found in A. Whereas in illustration D, A and B being traders enter upon a contract. A has private information of a change in prices which will affect B's willingness to proceed with the contract. A is not bound to inform B. Nonetheless, there are some exceptions to this rule. Illustration B and C to Section 17 show how the two exceptions operate. Illustration B to Section 17 provides that B is A's daughter and has just come of age. Here, the relation between the parties will make it A's duty to tell B if the horse is unsound. As seen in the judgment of Lau Hitian and Hagel Engineering, where it was stated that a duty to disclose material facts exists in the case of contracts uber fide or where there is a fiduciary relationship between the parties. Reference was made to the case of Bell and Lever Brothers Limited. Thus, it can be noted that a duty to speak arises in fiduciary relationships and in contracts of uber fide, which encompasses all contracts of insurance. Two federal court cases, Tan Keng Hua and Safety Insurance Co. and Abu Bakar and Oriental Fire and General Insurance Co. Limited, show that the proposal is under a duty to disclose all material facts, though reference was not made to Section 17. Meanwhile, illustration C to Section 17 provides another exception to the rule that silence does not amount to fraud. It reads, B says to A, if you do not deny it, I shall assume that the horse is sound. A says nothing. Here, A's silence is equivalent to speech. There have yet to be any case law to show in what instances silence can be said to be equivalent to speech and what qualification is.
An interesting point to note is that Malaysian law provides that fraud by silence will not render a contract voidable if the party whose consent was so caused had the means of discovering the truth with ordinary diligence for himself, or otherwise he or she can be said to have failed to fulfill his or her duty to exercise ordinary diligence. This exception will not apply to cases where the party concerned did not have the means of discovering the truth with ordinary diligence. Thus, exception to Section 19 of the Contracts Act provides that if such consent was caused by misrepresentation under Section 18 or by silence fraudulent within the meaning of Section 17, the contract, nevertheless, is not voidable if the party whose consent was so caused had the means of discovering the truth with ordinary diligence. In another case of Reta Construction and Law Ying, the plaintiff's intention in buying a piece of land from the defendant was to immediately sell it to a third party for a quick profit. When the sale to the third party did not materialize, the plaintiff tried to rescind the contract by alleging that the defendant had falsely represented to him that the land was 500 yards from Cebu Airport. It was in fact 8 to 9 miles away from the airport. The court held that even if the defendant had made the alleged statement, the plaintiff had chosen not to inspect the land before executing the transfer, with the defendant in views of his plan to make a quick profit by selling it to the third party. The plaintiff cannot now complain after discovering the defects. In the words of the exception Section 19, the plaintiff had the means of discovering the truth about the real location of the land by the exercise of ordinary diligence, but chose not to do so. As stated earlier, exception to Section 19 applies to any misrepresentations under Section 18 and fraud by silence under explanation in Section 17. It does not apply to active fraud under Section 17A to E of the Contracts Act, and as such, the misled party in such cases of active fraud is not under a duty to exercise ordinary diligence. As seen in the case of Weber and Brown, Weber agreed to transfer to Brown an option to purchase an estate. Weber fraudulently represented that he had counted the numbers of trees on the estate and even wrote that number on a piece of paper and later gave it to Brown. Later, Brown found that the number of trees to be fewer and sought rescission on the grounds of fraud. Brown sought to rely on the exception in Section 19 to resist Brown's claim, arguing that Brown could, with ordinary diligence, have discovered the truth by counting the trees for himself. The court held that the fraud did not arise by silence but by false and fraudulent assertion. As mentioned earlier, the exception to Section 9 applies only to fraud by silence and not an expressive false and fraudulent assertion. Hence, Section 9 exception did not apply and rescission was allowed.
Caveat emptor is a Latin phrase that is translated as let the buyer beware. It is derived from the principle that the buyer alone is responsible for checking the quality and suitability of goods before a purchase is made. In other words, the buyer needs to know their rights and be vigilant while making any purchases. The increase in the density of modern commerce has placed the buyer at a disadvantage with the rule of caveat emptor. There seems to be a decline in the rule, and which is due to the changes in the market situations. The trend is moving from consumer-oriented to consumer sovereignty. With the trend in mind, what are the rationale that leads to a change in this rule? Are the consumers given more importance as days go by? Now we'll look at the case of Lau Hitia and Hagel Engineering Sendrian Berhad and another in 1980. Lau purchased a loader on hire purchase terms from Hagel. During negotiations, Hagel's dealer did not inform Lau regarding the machine's year of manufacture or that it had been previously involved in an accident. Neither had Lau inquired about these matters. Subsequently, Lau sought to rescind the contract alleging that the material of non-disclosure of facts. Relying on the explanation to Section 17, the court held that there was no active duty on the dealer to inform Lau of these two matters. The general rule is caveat emptor, let the buyer beware. Have in mind, what if caveat vendita was the rule used here? Will there be a difference in the decision of the courts? Caveat vendita is a Latin term which means let the seller beware. The person selling the good is accountable for providing information about the good to the buyer. It's a counter to caveat emptor and suggests that the seller can also be deceived in the market transaction. The rule of caveat emptor is slowly being taken over by caveat vendita, the transform being recognized to a more consumer sovereign market wherein a commercial transaction are being encouraged. Such a change no doubt would help to create an appropriate balance between the rights and obligations of the seller and the buyer. In the context, the comment of Lord Wright, which are relevant, reproduced here. The old rule of caveat emptor had been superseded by caveat vendita, such change being rendered necessary by the conditions of modern commerce and trade. Let the buyer beware is not a phrase that judges use very often nowadays. The ancient rule of caveat emptor, which had its origin in the law, has over the period undergone foremost changes. As the rule was being given a solid shape, its exceptions also grew with time. Therefore, this conceptual change would center around the balancing point of the necessity of disclosure of information by the seller on one side and implications of reasonable inspections done by the buyer on the other side. With caveat vendita applied to this case, the decision would have been different. The seller would have been required under the law to inform Lau about the machine's year of manufacture and that it had been involved in an accident, even though Lau had not inquired about it. This provides more justice as the buyer would not have known what to ask or might have missed out on some matter. Next, another field to be reformed in the Malaysian law is the issue regarding ordinary diligence. As explained, there is a duty to discover through extraordinary diligence in Malaysia. The problem in this is that what is considered as an extraordinary diligence? The term extra was not clear and might cause ambiguity. However, English law differs as the general rule states that there is no duty to discover the truth with ordinary diligence. In the case of Norton and Lord Ashburton in 1915, it was said that no one is entitled to make a statement which on the face of it conveys a false impression and then excuse himself on the ground that the person to whom he made it had available the means of correction.
As we can see above, the general rule in English and Malaysian position is just the same, where there is no general duty of disclosure and one is normally not obliged to say anything if he is aware of the false representation. However, in some situations, silence amounts to misrepresentations. There are some exceptions subject to the general rule of Malaysia as well as English position. In English contract law, there are several exceptions which are active consumer of a defect in goods to be sold, contract over remain fide, which means utmost of good fare, partial non-disclosure, which also means half-true, and statement that is true that subsequently become false. Whereas in Malaysian position, there are only two exceptions to the general rule, which are the existence of fiduciary relationship in contract over remain fide, which involves contract of insurance and family matters. Another exception is that silence is equivalent to speech. As we can see that Malaysian law is sticking to the general rule as there is no much exception that allows silence amount to misrepresentation. Lastly, there is also a difference regarding to the duty to discover the truth between English and Malaysian law. In English law, there is no duty to discover the truth true even though there is means provided for the party to discover the truth. Whereas in Malaysian law, there is duty to discover the truth if there is means provided. As discussed above, we can see that there is limit assertion in Malaysian position. Hence, reform is a must to enforce as it can benefit the society. The importance of having the information being disclosed is worth mentioning, whereby it could be viewed as a means to save costs that were socially being wasted while looking for the information that the other party had already possessed. Such requirements can also prevent the inducement of a party to invest in wasteful precaution for information to be generated, where in fact, such information could be transmitted by the other at trivial marginal social cost. It is suggested that the law should require the party to disclose the material facts unless such disclosure would involve significant efficiency costs.